Hi everyone, welcome. My name is Samantha Reddy and I am a content manager at LexisNexis South Africa. We have a very short session today, so we're going to jump right into it. Our LexisNexis Agility Matters Express webinar series is designed to keep our customers updated in a flash with the critical content that they need to know right now. Today's session in part one is focusing on how to prepare for the upcoming bar exams. We will be dealing with legal writing, and the next one on Thursday morning will focus on civil trials and ADR. We are very thankful today to have Advocate Chris Marnewick joining us from New Zealand, who has so kindly given us his time and expertise. Chris is the author of Litigation Skills for South African Lawyers. Chris, over to you.
Thank you. Hello, everybody. We don't have much time, so I'll jump right into it. You need to prepare for the process of writing the legal paper exam. Could I have the first tile on, please? The second one, please. This is my general advice. I'm going to race through it very quickly. You are given 15 minutes before the time starts running for the writing, and I suggest that you use that period as follows. First of all, read the exam paper very carefully. Then arrange the questions from easy to difficult, and I suggest that you plan to answer them starting with the easy ones first and leaving the difficult ones for later. You should also plan to allocate time according to the number of marks allocated. If in a 50-mark paper, there's a question that is allocated 25 marks, you should have 25, or you should have half the time allocated to that particular question. Secondly, watch the clock. Sometimes you will need more time for the difficult questions, and you should keep that in mind. When it comes to general exam technique, I think you should use the system that we use in all our legal writing. Arrange things in paragraphs and number them. Use bullet points and numbers. Next issue, if 5 marks are allocated to a particular question, try to find 5 points that are relevant to the answer to that question, and then number them. The same would apply to a question that says, let's say, has 10 points allocated to it. The whole idea is that you should impress the person who has to mark your paper with the arrangement of your material, of your answer. Could I have the next tile, please? Now, the prescribed works, or the ones that I would suggest you use for legal writing, apart from the fact that you should actually have studied civil procedure using one of the commentaries on civil procedure. LexisNexis has the book by Harms. The title, if I remember correctly, is Civil Procedure in the Superior Courts. That kind of book would be essential not only to your preparation for the exams, but also to your practice as an advocate. The ones I'm going to talk about tonight, it's tonight here where I am, by the way, are Litigation Skills, my book, and Amler's Precedents of Pleadings. A quick word about my book. I wrote it in order to defeat the bar exams. When I wrote that book in 2002, the failure rate at the bar exams was 40%. And most of that 40% came from what I would call as disadvantaged universities and schools. The bar exams at the time were closed book exams. You weren't even allowed to use my book. As it happens, it was banned from the exams. Nowadays, it's an open book exam. So I would suggest, if you possibly can achieve this, have a copy of my book available, together with the other book by Justice Harms called Amler's Precedents of Pleadings. In my book, you will find precedents of all the documents that you are required to be able to draft in the legal writing exam. Could I have the next slide, please? Now, these are the documents that are in the bar exam for legal writing. Opinions and memoranda and advice on evidence. They are a species of their own. Then we get to claims, then defenses, then exceptions, which are a species of defenses. Then we have applications, which means notice of motion and affidavits. Then we have a request for further particulars, then some appellate documents and heads of argument, which would be relevant also to your civil trials exam. The methodology for each of these categories is explained in detail in my book, and in Amla's book, Justice Haram's book, there are precedents for a vast array of claims and defenses. You must use that book in the bar exam. If they ask you to draft a plea or a special plea, you will be able to find an example of the particular defense that you want to raise in Amla's. If you want to see the format, you'll see that in my book. So please use those books. I know they're expensive, but for the purposes of your preparation for this very, very important exam, you should either borrow it or share it if someone has it who is prepared to share with you. Could I have the next slide, please? Now, there's a chapter in my book, chapter 2, dealing with opinions and memoranda. It's in the chapter dealing with giving advice to a client. Now, the general advice I can give you with regard to opinions and memoranda is this: study that chapter in my book and then create a structure for yourself for an answer to a question of this nature. An opinion or a memorandum should have an introductory section. You can head it. Remember, signpost what you're going to do. I suggest the 4 paragraphs that you see on the screen: introduction, discussion, analysis, conclusion. In the introduction, you state the question that you have been asked as an advocate now to answer, or what advice you have been asked to give. Then that should be followed by a different section, which would be a discussion by you of the factual background to the question that you have to answer. In the next section, headed analysis, you would discuss the facts and the law and explain the reasoning that you've adopted or that you will be using to reach the conclusion, which is the final part of the advice. Now, the clients will have come to you, and the examiners will look for this when marking your paper. The clients have come to you for advice. They want to know what the answer is to a particular legal question, or they will want to know what they should do in a particular situation. You must give that answer. This is a place where you are allowed, by the way, to say that on the facts and the law, no definitive answer can be given, and that the client should proceed with caution. That's enough for a good exam answer. In practice, of course, you'll have more time. You'll be able to take advice from your seniors, and ultimately you may be able to answer the question one way or the other. Thank you. Could I have the next slide, please? A section that you will have to study in detail for both this exam, legal writing, and for the civil trials exam is the drafting of pleadings generally. Amla's precedents of pleadings has examples of the different claims and defenses that you may raise. My book has an explanation of the general principles in chapter 5. But in Amla's precedents of pleadings, from page 1 to 12, actually, not 10, you will find a detailed summary. It's a bit of a contradiction in terms, but it's a detailed summary of the basic rules of pleading. Rule 18 in the High Court rules is the relevant rule. you are going to live with that rule all your life as an advocate. So get it under control now. Note here, every pleading must have a prayer. So in a claim, you will pray for judgment, for whatever, payment of money, divorce, damages, or whatever. I'll come to that again later. Just note in passing, further particulars and a request for further particulars are not pleadings. So they don't have to have a prayer. Do I have the next tile, please? There are different kinds of pleadings that constitute claims. The most common one is particulars of claim. Then a declaration, counterclaim, third-party claim, and an interpleader claim. You will see examples in my book. The page numbers are given on the screen as you see. For example, declaration is at page 109. There's actually an example of it. What you will notice about claims is that they all have the basic structure, but the formats are different, and these formats are designed to suit particular purposes. The third-party claim, for example, if you study the rules relating to third-party or third-party claims, you will notice that the pleader has to do certain things which include attaching copies of the prior pleadings in the case to the third-party claim. So the format differs, but the basic content will be the same. I'll get to that on the next tile. In the meantime, remember, there must be a prayer, and the prayer must be supported by the facts pleaded in the preceding paragraphs. You cannot ask for something in the prayer which is not justified by the facts that have been pleaded. Conversely, everything in the prayer must be justified by the pleading itself. There shouldn't be anything which is superfluous to the particular claim in the particulars of claim, and conversely, nothing that is justified by the facts that you've pleaded should be left out in the prayer. Asking for further or alternative relief is not going to save you if the pleading itself does not justify the particular relief that you want. Could I have the next tile, please? I've put together an example here of a typical particulars of claim or declaration. This will also apply to a counterclaim adjusted as may be necessary, and also a third-party claim and an interpleader claim. Let's start with the basics. Paragraph 1, you need a plaintiff, and you have to plead the personal details of that person, plus indicate his or her or its locus standi. Now, what I mean there by personal details is what is required in the rules. Full names, occupation, address, whether that person is an adult or not, and if that person is suing in a representative capacity, what that capacity is, and so on. The same goes for a defendant. Look at the rule, Rule 18. It requires all of those details. We then get to jurisdiction. Now, jurisdiction is not pleaded by virtue of a legal statement. The court has jurisdiction, period. Jurisdiction must appear from the other facts that you've pleaded. In most cases, jurisdiction will appear from paragraph 2 of your particulars of claim, where the defendant is resident within the jurisdiction of the court. Or perhaps jurisdiction will be apparent from paragraph 4, if it is not already apparent from paragraph 2, where the conclusion of the contract or performance of the contract occurred within the jurisdiction of the court. Or the delict, if you're suing in delict for damages, the delict was committed within the jurisdiction of the court. Then the court will have jurisdiction. But those facts must be pleaded then in a way that the court can deduce from the statements that you've made in the pleading that it has jurisdiction. If you are pleading a claim for a divorce, for example, there will be usually be an allegation that the parties are domiciled within the jurisdiction of the court, or that the plaintiff is domiciled within the jurisdiction of the court, and that the court has jurisdiction over the defendant for some other reason. You should study that independently of my book and the Haram's Precedents of Pleadings book in order to come to grips with that. In any event, in the example that I'm giving here, we're talking of the conclusion of the contract. You have to give sufficient details to allow the other party to plead. When, where, by whom, and a copy of written parts will have to be attached. The material terms, there are usually two sections there. The one would be the plaintiff's obligations, the other would be the defendant's obligations, plus the time for performance by each of them. Paragraph 6, you have to plead performance by the plaintiff of his or her obligations, and otherwise you can't sue the defendant. Your claim will be premature. Next paragraph, you've got to plead the defendant's breach plus details. Then if it's a damages claim, you have to plead the details of the damages plus a demand, continued failure to pay, and then you get to the prayer, which usually in a money claim would be payment, interest, and costs. Could I have the next tile, please? We now get to defenses. This is where it gets a little bit more dependent on your personal style. The basic principles are set out in the rules. They're quite specific. It's Rule 18, if I remember correctly. No, sorry, Rule 22, or thereabouts. It's not the number of the rule that matters, but the content. There are different choices that a defendant has when it comes to pleading, say, to a particulars of claim or a declaration. First of all, an allegation may be admitted. How you plead an admission is explained in my book at page 135. And it's usually enough to say the defendant admits paragraph 4 of the particulars of claim. Then we get to a denial. A denial has to be more specific, where, and you see the example at page 136 of my book. There you will see that the basic style is to say the defendant denies the allegations in paragraph 3 of the declaration. Some people will say the defendant denies each and every allegation in paragraph 3 of the declaration as if specifically traversed herein and puts the plaintiff to the proof thereof. All of those additional words are meaningless because if the defendant denies the allegation, then the plaintiff has to prove it. Next is a confession and avoidance. Confession and avoidance means that you admit something, but you have an explanation for it. So then the defendant would plead, the defendant admits the allegations in paragraph 3 of the paragraph 7 of the particulars of claim, but alleges that he has paid the full amount owed to the plaintiff. Okay, so you see the answer is yes, what the plaintiff says is true, but I've paid him. That's called a confession and avoidance. The High Court rules allows the pleader to say that an allegation is not admitted. This happens where the defendant doesn't know whether an allegation is true or not. In such a case, the defendant cannot say, I deny those allegations, because that in itself is a positive averment which says what the plaintiff is saying here is untrue. If you plead that the defendant does not admit the allegations in paragraph 10 of the particulars of claim, that means that the plaintiff still has to prove that allegation, but that the defendant has no counterproof. The rule requires you, next item, to plead the material facts. Now, the material facts of a defense are those legal elements of a defense that you need to prove in order to succeed on a special defense. Let's look at prescription. In order to succeed with a plea of prescription, the defendant has to plead the date when the debt arose. Secondly, the period of prescription which is applicable to that kind of debt. And thirdly, that the plaintiff's summons was served on the defendant outside of the relevant period, which is usually 3 years, 6 years for some instruments, and 30 years for judgment debts. The rule also requires that an explanation or a qualification should be pleaded in some detail. Look at page 139 of my book and you'll see what is intended with that one. There are 2 notes here, which I suggest you take into account in your exam. The first is the prayer in the plea. And remember, the plea must have a prayer. The defendant should always ask for judgment in his or her favor. I see some pleaders ask that the plaintiff's claim be dismissed with costs. When a claim is dismissed with costs, it means that the plaintiff has not proved its claim. And that amounts to absolution from the instance. And the legal effect of that is that the plaintiff, if the claim has not become prescribed, may start all over again with a new summons. You don't want that. You want judgment for the defendant, and then the judgment is final. And unless it's upset on appeal, there's nothing the plaintiff can do about it. Secondly, you should study the role and purpose of a special plea very carefully. I explain that at page 144 to 146 of my book. Could I have the next tile, please? I've now given you, as quickly as I could, and perhaps a bit superficially, some advice about how you can prepare for the exam and how you should approach the exam when you're sitting down to write it. There are other parts of the syllabus which we haven't covered. There's just not enough time to do so. They are exceptions, replications, applications, plus an application for leave to appeal, advice on the evidence, request for particulars, and heads of argument. Each of those, as you can see on the screen, is dealt with in a chapter in my book. I suggest what you do is what I've done with the particulars of claim, example that we used earlier. You sit down and you make for yourself a list or a precedent, if you will call it, might call it that, or an example. If you were, for example, to have to prepare an exception, how would you word it? There would be 3 or 4 steps and it would have a prayer. Prepare a little example for yourself, write it out. It always helps to write these things out because as the pen writes, the memory fixes that particular item firmer in your memory than just reading something. Let's look at advice on evidence. If they give you an advice on evidence to do in this exam, it will be allocated quite a hefty share of the marks. And that is money for jam. Look at the precedent or the example in my book, and you will see that there's a structure to it. And it's easy to remember. You will be allowed, as it happens, to have the book with you in the exam. You can follow that structure, of course, adjusted to the facts that they give you in the exam. The same goes for every other question in the exam. You've got to modify your response when it comes to the structure of the particular document you have to prepare to accord with the particular facts that they provide. Let's look at requests for further particulars. That one could be a bit tricky. Now, a request for further particulars is supposed to be a request for particulars for trial. Excuse me. Now that should only happen after the pleadings have closed. And then it means in turn that you should have the particulars of claim and the plea in front of you. Now, there's no purpose in asking further particulars to a paragraph or allegations in the particulars of claim that have been admitted. You will focus on working out by going through it paragraph by paragraph to determine what the issues are in the case. Let's say there's an allegation that the defendant caused a collision by driving negligently, and that is denied. You will aim your request for further particulars at that paragraph, not to the identity of the plaintiff or even where the accident happened. So focus on the issue between the parties and direct your request for further particulars to those issues. Heads of argument, again, if you get that in the exam, it'll be allocated a hefty share of the marks. I would guess in a 100 marks exam, heads of argument would probably get to 20 or 25 marks out of that paper. So again, use the example in chapter 25 of my book. There's a structure that is provided by the Supreme Court of Appeal rules. I think there are about 10 sub-rules that you have to comply with. You need to be very careful with that. And again, as I say, you can get a good number of marks for being fully prepared on a question like that. I think what I've now done is what I've tried to do is to show you how to prepare for the exam. I've given you a couple of specific examples, particulars of claim, defenses, memoranda and opinions, and I'm pointing you in this direction, giving you homework as it might appear to you, to go and prepare yourself now on these other ones that you see on the screen at the moment. Remember, you're an advocate. What an advocate does when a problem is given to an advocate is they hit the books. You don't practice from memory. You hit the books, you go and look for help there. Then you start working methodically through the problem-solving process. And then you, in legal writing, you sit down and you draft the particular document, you consider it afresh, you redraft it as necessary. The process is never really over until that pleading or document leaves your chambers. But the hard work is simply done by reading the instructions carefully, considering the problem, identifying the particular troubling spots or trouble spots, and then using a tried and tested structure to write the particular document. That is my overall message to you. There's a structure to each of the documents that you need to write in legal writing. And if you're prepared properly on those structures, you will be ready for the exam. Good luck with the exam.
Oh, thank you, Chris. Thank you so much. Such helpful points for our pupils to consider. Okay, just before we sign off, I want to mention that LexisNexis has a number of prescribed print works for the bar exam and also offers Lexis Library discounts for pupils, baby juniors, and new advocates. Please can I also ask that you complete the on-screen poll that will be up for only a few moments. This is to help us request any further information that you could use to prepare for your exams. I hope that you found this quick update helpful. Please remember that we designed this webinar to help you with your exam prep and give you guidance on common focus areas. It should not be taken that everything covered here will be covered in your exam, or that everything covered today are the only areas that will be included. Please note that today's recording will be made available to you in a couple of days. Also remember that part 2 of the webinar is going to be held on Thursday morning and will focus on civil trials. Thank you so much for all of you joining, and we wish you all the very best with your exams. Thank you. Stay well.